Hi, good afternoon, everybody. I'm Doug Cha, the Executive Director for the Governance Center here at the Conference Board. And welcome to today's edition of Governance Watch, our webcast series that we host in collaboration with Cleary, Gottlieb, Steen, and Hamilton. Today, by popular request from our members, we're covering a pressing topic on everybody's minds, which is cybersecurity. And so cyber attacks, as you know, and data breaches have been making headlines at an alarming rate. One article we recently came across said that over the past year, we've seen a 350% increase in ransomware attacks, 250% increase in spoofing or business email compromise attacks, and 70% increase in spear phishing attacks in companies overall. And so today we've convened a panel of experts to share their thoughts on what the current risks are, how cyber attacks are changing, and what role management and the board should take in ensuring their companies are as prepared as possible. So I'm pleased to be joined by three guests who have been on the front lines, Alexis Collins, Daniel Ilan, and Nick Mankiewicz. Alexis is a partner at Cleary Gottlieb. Her practice focuses on complex civil and antitrust litigation, criminal and regulatory enforcement matters, and cybersecurity. And prior to joining Cleary, Alexis was a deputy chief of the counterterrorism section at the U.S. Department of Justice. Daniel Ilan is also a partner at Cleary Gottlieb and prior guest here. His practice focuses on intellectual property law, cybersecurity, and privacy. And finally, joining us remotely is Nick Mankiewicz, who is the Vice President and Chief Information Security Officer at the medical technology firm Becton Dickinson, also known as BD. In his role, he is responsible for protecting the company's information asset confidentiality, integrity, and availability. Prior to BD, Nick was at Philips Electronics, as including the corporate research department head, specializing in IT-based innovation. A couple of housekeeping notes before we get started. We're offering CPE and New York CLE credit for participating in today's live program. And to get credit, you need to stay online for the entire webcast. For CPE credit, the process is entering your full name, email address, and specifying CPE at the request CPE credit space at the bottom of your screen. 3 pop-up messages will appear during the course of the program, and please click OK each time you see one. For New York CLE credit, you need to download the CLE verification form and evaluation form posted in the download section at the bottom of your screen. Complete them and email them to Cleary Gottlieb at the email address provided on the forms. We will provide a verification code later in the webcast, which you will need to write in on the form to earn the credit. And so, as you'll see, we provided 2 articles related to the subject matter in the download section at the bottom of your screen, and we will also email those out to viewers today. We welcome audience participation, and so type your questions in the chat box at the bottom left of your screen. I will see them and try to work them into the discussion as we go along. You can download some of the background readings that we have. You can enlarge your video screen to full screen by clicking the arrows in the upper right-hand corner. And please do complete the evaluation at the conclusion of today's programs so we can get information on what you'd like to hear about in future webcasts. And there will be a link to share the program with your colleagues for replay a little bit after the program concludes. So Now that we've dispensed with that, let's get into the discussion here. Um, First, we're going to talk about this primary cybersecurity issues facing large companies. And so, maybe Daniel, you can set the stage. At a high level, when we're talking about serious cybersecurity risks, what exactly are we talking about here? What's the scope?
Sure. We're talking about information security incidents that materially and adversely affect the confidentiality, the integrity or the availability of data or systems of the company. And as you mentioned, and as we all know, what people mostly think about in this context are the big data breaches, situations where companies that have collected large amounts of consumer user data, customer data, are subject to a cybersecurity attack, the purpose of which is to access the data, steal it, and use it for reasons that could be criminal or others. However, and of course, in this context, only recently we heard about the Marriott situation, which was really a cybersecurity incident involving Starwood, a company that Marriott acquired in 2016. But the breach did involve large amounts. I think now they're talking about 380 million users' data implicated. We know about the Yahoo attack, which involved right now, years after, seems to be around 3 billion users, Equifax and others. So these incidents really catch the eye and the headlines. However, it's important to remember that those very significant, serious, sometimes life-threatening for a company incidents can involve other types of data. It doesn't have to be consumer or user data. And in some cases, it is trade secrets. It can be other sensitive information. It can be information that is damaging for the company if it is revealed. And I'm dealing very often with companies in aerospace, in technology, of course, in chemical engineering, where we know that the cybersecurity threat is not about user data, customer data, but about those trade secrets or that information that is stored on the company systems, the discovery or unauthorized disclosure of which will be detrimental. It is also important to remember that those very serious cybersecurity incidents do not need to involve theft of data or actual access to data, because, as I'm sure Nick will discuss later, and I think as you mentioned with respect to incidents that are occurring more often, one of the primary example for cybersecurity incidents nowadays is the ransomware attack, in which the purpose is not to get access to credit card information or other data that can be then resold on the dark web or exploited for some criminal purpose, but the purpose is actually to lock the data, make it unavailable, or lock a system, a database, make it unavailable for the company such that the company just cannot operate. Think about a hospital where patient data is just not accessible. Any company that has to deliver goods, logistical operations are shut down because databases are not accessible. And the hacker in this case is asking for, of course, ransom money in the form of bitcoins in exchange for releasing the data and releasing the system. So again, important for all companies and boards of directors to remember the serious incidents do not only affect companies that are the Yahoos, the Marriotts, those that have a lot of consumer data. They also affect and can be detrimental to companies that have other types of data. And it's not always a breach to the data, disclosure of the data. Sometimes you're just making it unaccessible.
Sure. Okay, good. Nick, in previous discussions, you and I were talking about, for your company, there's, theft of secrets, trade secrets, obviously. But then there's also privacy of patient data. That's a very big thing for a medical company. How does privacy factor into your thinking around cybersecurity?
Yeah, I think privacy is a really serious concern. I think we actually need to secure systems for a variety, and I think as Daniel correctly said, confidentiality, integrity, and availability. I think privacy poses very special risks because not only is it a reason that people come after your data so they can monetize, somehow steal credit card numbers, but privacy itself is a right and is regulated. And so privacy itself is a necessary part of what societies expect. And security is one critical component in guaranteeing and ensuring adequate privacy. So the downside risk of a breach can be rather considerable. But when it involves personal data, especially when it involves personal health data or sensitive data in the European sense, your damages can be much, much higher. So we have to take special attention at the prevent stage to make sure that we are protecting these highly confidential or secret assets, and we consider personal health data the most secret of assets.
And so, with regards to privacy, for lawyers and others in the IT space, there's been a lot of talk about GDPR compliance. And so, while GDPR is really associated with data privacy and kind of the movement of personal information, in kind of and so are there cybersecurity implications, or does GDPR at all address any kind of cybersecurity or data breach situations?
Actually, they're very deep implications. I think number one is GDPR contains assurance of adequate security to ensure privacy. So there are a lot of controls that you have to be able to demonstrate that you have in order to assure that information will be kept confidential and private. I think more seriously, one that's often not thought of, that I think for this audience is important, is the very act of securing an organization means that there is surveillance that goes on to watch what's being sent out. If 30,000 credit card records or HR records or social security numbers get sent out, I actually need a surveillance campaign that allows me to monitor what's leaving the company. That surveillance itself is an important aspect. So I view myself as an important compliance element in terms of my controls, but I think very importantly and often neglected is I have to be very conscious of GDPR to understand what I am allowed to watch, what notice I give about watching, what opt-out options are available in terms of my internal security surveillance, so that I can assure the confidentiality, integrity, and availability of information.
That's interesting. Yeah, go ahead.
I just wanted to add to what Nick said about GDPR. So GDPR also has a breach notification obligation that today all states within the US have. The difference is that the GDPR breach notification obligation requires notice to authorities within 72 hours. So 72 hours after becoming aware of a breach, you need to notify the authorities about it. And the GDPR also has the security rule that Nick talked about. And of course, many other things that are not the subject of this discussion. But I think the reason why GDPR got so much attention is not all of these rules, it's the potential enforcement implications that GDPR provides for, namely the very significant fines that can be imposed by the data protection authorities. So the GDPR says that for these types of very serious violations, including with respect to providing security to data or failing to provide notice of a data breach, which often happens, I'm sure Alexis will discuss some of the situations where companies are delaying notice of a data breach. And the GDPR provides for fines of up to 4% of global annual turnover of the whole group of the affected company. So if a company such as Nick's has a subsidiary in the UK, for example, and that subsidiary fails to respect these obligations under the GDPR, theoretically, the fine that can be imposed is 4% of the whole group's, not just the UK subsidiary, the whole group's annual turnover, which in the case of big companies is just unimaginably huge.
Yeah.
And so that's the reason why people talk about GDPR so much. Early indications are that the authorities are not imposing these fines yet, but clearly there is a serious concern about a breach of GDPR, and that adds, of course, to all the other cybersecurity incident implications and potential litigations that you already had. So it's another thing that makes this a very important topic for discussion.
Okay, well, that's a good segue into what we wanted to talk about with Alexis in terms of data breach litigation enforcement that you saw in 2018, and maybe you could just give an overview and some of the trends that you noticed there.
Sure. In terms of, as you mentioned in the very beginning, the amount of data breach litigation has continued to increase, and with that more litigation, what we've seen is it's actually getting harder for companies to achieve dismissal of those cases early. The threshold issue that was litigated in years past was standing, whether the plaintiffs in these cases, particularly in consumer litigation, the actual affected users whose data was compromised. The main question, the threshold question there was, have they alleged an actual injury? Is there an injury in fact? And a circuit split developed in recent years where some circuits have said that plaintiffs don't have to allege an actual injury. It's enough if they allege increased risk of injury, such as identity theft or credit card unlawful use of their credit cards, unauthorized charges, that sort of thing. And so with that circuit split, we're seeing cases, and we did see cases migrate to those more permissive circuits. And so companies were having a harder time getting those cases dismissed on that early threshold standing grounds, which left companies arguing defenses based on state law, because that's the law under which most of these claims are brought. And state law obviously varies according to the various states, and so we've seen very inconsistent results across jurisdictions, where the same cause of action is being alleged, but because one state law has different requirements, cases are getting stopped, whereas other cases are going through. So these cases are now starting to move more frequently towards discovery, as well as possibly merit stages, which increases the risk to companies as well as the costs of those litigation. In addition, resolving these cases is also becoming more costly. We've seen some record settlements, particularly in the consumer context. So for example, Anthem recently settled lawsuits alleging brought by consumers who alleged compromise of their data for $115 million, and that covered about 80 million users. You compare that to 2015, when Target settled a similar case involving 31 million users for only $10 million. So clearly, settlements have gone way up.
And Anthem being a much smaller company than Target.
Exactly. And we're also seeing that in the regulator sphere as well. The state attorney generals recently settled with Uber for $148 million over their, I think it was 2016 breach. So the settlements with both consumers as well as regulators has begun to skyrocket.
And these cases the civil ones primarily take the form of class action suits, is that right?
Yes, and we're seeing them filed the day that disclosures about a possible breach are made. There's not very much lag time.
Sure. Has there been any shareholder derivative actions on this front or not yet?
There have been, and I think we saw more of them in the past. The standard is so hard to surmount for those, so you're seeing fewer and fewer of those. However, there was a recent settlement, I think it involved Wendy's, where they settled for $950 million in attorney's fees as well as certain remedial actions. So that settlement may breathe new life into the shareholder derivative suits, but on the whole, we saw those declining.
Got it. Okay. Nick, maybe you want to touch upon some of the trends that you've seen and are seeing that you think particularly boards of directors would need to know.
Yeah, I think boards have become more aware that they really need to build their understanding of cyber and how cyber risk fits into the overall enterprise risk management. So I've certainly seen a lot more attention from the boards. I've seen a lot more attention in these kinds of webinars that really are trying to understand what the board's role is. And so there's actually now a number of very good downloadable publications about the board's role in cybersecurity that are quite informative. I've seen them from a number of the major consultancies. I think overall, the board needs to become conversant with cybersecurity. It can't, I think, can no longer be just a marginal issue for the audit committee to touch on once a year. I've seen some guidance that says you actually should have a standing agenda item in the board for cybersecurity on a regular basis. Perhaps an audit committee does that a little less frequently. But I think the board ultimately wants to have the confidence that corporate leadership is taking this responsibility seriously with a number of very specific actions. Have they done a gap analysis with an external organization or consultant? Do they have a program that's built upon the knowledge of the risks and gaps? Is that program progressing? And I think the simplest way, my recent interaction with the board just within the last few weeks in the wrap-up of a cybersecurity exercise for the board really was about having the dialogue with the board, making sure that they understood what the program was broadly, and that we were aggressively maturing our organization in its skills of people, process, technology, while at the same time monitoring the risk and reducing the risk in a demonstrable way. So maturity up and risk down. And I think that gave them some confidence and gave them at least the paradigm for dialogue with cybersecurity and with the audit committee.
Okay, got it. On the management front, what should companies be doing to prepare for a potential data breach or cybersecurity attack? I mean, at this point, people, the talk is, look, it's pretty much inevitable that your company is going to have something like this. It just depends on the severity. And so, when you think about giving advice to companies based on your experience, what do you think in terms of both prevention and post-incident containment and PR and all of that in terms of preparation?
Yeah, I think there are some very basic lessons. I think first, is there an accountable leader for security? Does that leader have semi-independence from the IT folks? IT folks are artificially selected to create frictionless pipes, and security has to make sure the friction is appropriate to breach prevention. So I think get leadership, assure the right relationships and governance, make sure that the organization is looking at a standard against which to judge their current readiness. Whether it's the NIST, National Institutes of Standards and Technology Cybersecurity Framework, that's a very good one. We've chosen that one because it's very simple. You don't have to be a technical person to understand the idea of the very simple five dimensions of that. Or the ISO, if you're a European company, using the ISO 27000 series. But pick a standard, assess against that standard with credibility, that is with help and assurance from an external organization, and then look at what are your big gaps in terms of likelihood of a breach and impact of a breach. Start at that upper right-hand corner and start creating a program of projects that will bring that risk down, lower the likelihood, lower the severity. And of course, have your overall risk management program, have cyber insurance as appropriate, but ultimately make sure that it's monitored, it's improved, it's continuously improved, and hard questions are asked all the time.
And so what about, that's prevention risk. What about the post-incident protocol and containment and all of the PR considerations that a company might have to go through? To what extent do you get involved in that as a CISO?
Very deeply involved. We are the team that does most of the incident management. So there are really two phases. One is to respond to an incident, and the other is recover. This is the NIST framework. So, you have to detect, you have to protect. When you do get an incident, you have to respond to that particular incident, and then ultimately you have to recover from that incident. That is both the continuous improvement of what have you learned, as well as make sure that this kind of incident can't happen again. So I'm deeply involved. I have a 1-inch thick manual that the incident team uses. We relate into, as a sub-team of crisis management, and we essentially organize, manage the response to an incident. If the incident's big enough, I cede that authority to outside counsel so that we can have it properly managed with privilege. I've been in situations in other companies where we've had a large event, and I suddenly became a supplier of technical information into an incident team that was really managed by outside counsel. So I think all of those elements have to be in place. And I think very importantly for boards in their oversight of corporate leadership is make sure that incidents have that accountability for who's leading the team, how's that team reporting to crisis management and into corporate leadership. Ultimately, how does that team do the post hoc analysis in order to understand root cause, in order to continuously improve, and ultimately working closely with legal counsel with regards to what are our obligations during a particular type of incident. I think Daniel correctly mentioned one of the big burdens of GDPR is a 72-hour response time for informing authorities when you know that a breach has occurred. You can look at the very interesting case history of the Marriott breach to see that these were breaches from 2015, came along with the acquisition. They became aware on, I think, September 8th. They worked it from September 8th until they were sure they understood the extent of the breach. So by, I think, October 30th, they were putting out a notice that 500 million records were accessed. And 5 weeks later, they refined that. They did their early notice as early as they thought they understood. Then suddenly it's 383 million. So I think knowing how to handle that, knowing how to deal with the imperfect information that you obtain while trying to analyze trillions of records in order to understand extent of breach, I think all those elements are critical for boards to be confident that leadership and security leadership is engaged.
Got it. And so, you know, you mentioned outside counsel several times, so that's a good tee up for Daniel in terms of, you know, how you get involved.
I would say one thing, and then I will let Alexis, who's more on the litigation side, comment on actually dealing with the post-incident environment. I would say, and kind of adding to what Nick has said, I think making sure that there is healthy communication between the different parts of the organization and making sure that there is ongoing reevaluation and reassessment of what needs to be done is really important, because past experience shows that in many cases, information that was held by one person or one portion of the organization didn't make it through to other parts of the organization, and other people that with that information could have acted in a way that would have prevented more serious deterioration. And so this communication, whether it's between the IT and the legal department, or the CISO and eventually the board, between the person who's responsible for software patching and the person who's responsible for the overall IT environment of the company. All of these things, when you actually look back at what happened, you discover that these things failed. The reassessment and the reevaluation is important because in real life, and Nick knows this better, these incidents are uncovered gradually, and the information is becoming available gradually, such that what you thought you knew in the beginning is often very different from what you know 6 months later, and maybe even different from what you know 1 year after the incident. And as we saw in Marriott's case, it's really Starwood. We should be accurate here. It's really the Starwood guest reservation system that was hacked. But the fact that information comes to life gradually requires us as outside counsel to reevaluate and reassess what needs to be done. For example, the most simple example is breach notifications. So different states have breach notification laws that are triggered by different circumstances. And it could be that in the beginning, you believe that there was no need to notify authorities or individuals, but then afterwards, new information comes to life that makes it clear that you do need to notify, or to European authorities under Gdpr. And if this communication is not healthy within the organization, and if there is no serious attempt to reevaluate and reassess what needs to be done as information flows in, you will really not be able to successfully contain the incident.
Yeah, Alexis, maybe you want to comment on the, yeah.
Yeah, no, I think that's absolutely accurate, particularly picking up on two themes that both Daniel and Nick indicated. In terms of the disclosures and notifications that companies are making, it's very important to be mindful of what you're disclosing, not only for the purpose of protecting privilege over documents that may underlie those facts and statements that you're making, but also in terms of whether subsequent statements materially change or render materially inaccurate prior statements that you've made. We've seen that be the basis of securities fraud litigation that's subsequently brought if stock prices drop after notification of a breach. So though that is critical, picking up on what Nick said earlier, another key that I've seen in preparing for the eventuality of a compromise or breach is actually practicing your plan. Through that, it allows you to reevaluate whether there are gaps, reevaluate the effectiveness of your plan. And it's important to do that with all of the different stakeholders in the room. So not just necessarily within the core confines of the IT team, but also making sure that legal and public relations and all of the different aspects of your company that will be involved in breach response are actually sitting at the table and they're practicing their plan against a scenario that's realistic for your company, that realistically portrays the risks that your company faces.
Got it. And what about, in terms of trends of litigation going forward? What would you expect to see that a company needs to anticipate?
Sure. We would expect to see increasing levels of litigation, as we mentioned earlier, particularly in class action by consumers, as well as we've seen, and I think we will continue to see litigation by payment companies and other vendors who may be affected by a particular breach or compromise, an increase in securities fraud cases where securities prices have dropped. Particularly when you've made disclosures prior to announcing the breach. I think you will also see increased SEC enforcement. That's something that we saw in 2018. They started out the year with publishing guidance on cybersecurity disclosures by public companies that really emphasized the notion that public companies need to consider cyber risks when in their public disclosures. And they followed that on with a $30 million settlement involving Yahoo for failing to disclose their 2014 breach in their subsequent annual and quarterly reports. The company had only disclosed the potential future risk of breaches, but not gone back and actually disclosed the breach as well as considered the impact of that prior breach on their financial performance. And so I think we'll see the SEC be more active in this area involving public companies. In addition, there's an increased activity by the FTC for enforcement. They're concerned more with unfair, deceptive practices towards consumers, but they have indicated that they consider failure to implement adequate cybersecurity protections as an unfair practice. So in addition to looking at whether companies are actually living up to the statements that they're making to consumers, they also look at, did the company have adequate practices to begin with? And so there's recent testimony actually by the FTC commissioners in Congress advocating for enhanced authority in this area to levy civil penalties as well as rulemaking authority. So I think we'll see that agency be more active in the future as well.
What about kind of the contractual transactional litigation, that could go on in terms of material adverse event and these types of things? What do companies need to be thinking about there?
Sure. I mean, that is absolutely a consideration, and part of it is knowing in advance all of the contractual provisions that might apply in the case of a breach, and that is something that can be thought through when you're forming your incident response plan and when you're testing it to make sure that you have at the ready all of that information, because when you're dealing with the crisis, as I'm sure Nick knows and Daniel, having been in the middle of it, there are all of these side risks that you're dealing with that are very easy to lose track of if they're not already considered in your plan.
Got it.
Yeah, I want to follow up on the transactional part. It's one of those things that boards have to know about, and in fact boards deal with, sometimes not properly, which is the cybersecurity risk that is associated with buying companies in M&A transactions. There are also other transactions that give rise to risks, data sharing and others, but just looking at M&A, which has been very active in developing, is really interesting. So in this area, we are seeing a totally new landscape. Like, talk about trends, talk about takeaways. This is a completely new world. If only 2 or 3 years ago, we hardly did real thorough cybersecurity diligence in an M&A transaction. We maybe did so when there was a real known big incident, and even then we just really scratched the surface. And nowadays, diligence is much more sophisticated. It is often not limited to legal counsel, but it involves also technical expertise and companies that are in the business of identifying vulnerabilities and identifying issues. And it's not only diligence, it's also the execution and implementation of transactions. You have much more robust cybersecurity representations in contracts, provisions addressing cybersecurity risks, indemnification, etc. And as we've seen already several times, cybersecurity risks are now elements that could cause a transaction not to go forward at all, or at least to go sideways and give rise to complicated issues. Why is that? When we buy a target, when we buy a company in an M&A transaction, we most normally we would assume the liabilities of the target. That's the case when you buy a company. When you do an asset purchase and you don't buy a corporation, you sometimes don't assume all the liabilities, but just those that are specifically coming over. But even when you only buy assets and you don't buy the whole company with its liabilities, you often buy IT systems and you buy databases. And if those are vulnerable, if those have been affected, if those have not been maintained properly, you now integrate them into your own systems and databases as a buyer, and there you go. You are just a breach waiting to happen. When you do an M&A transaction, you try to identify these big problems for these reasons. However, even the company itself, the target itself, finds it very difficult to identify these issues. In fact, there are statistics showing that it takes, in average, 197 days for a company to realize that it has been hacked. So from the point of the breach to the point of knowing that you have been hacked, you have been breached, it's around 6.5 months passing by. Then it takes more than 2 months more for a company to contain the breach. Because it's one thing to know that you've been breached, so it's another thing to understand what is the real impact. So what databases, what systems actually have been accessed, how much data there was. As Nick said, and we discussed earlier, in many of these cases, the famous name of breaches, Yahoo, Marriott, Starwood, in the beginning, it seemed to have been different from the real result in terms of how many people were affected, what systems were hacked. And so to understand what really happened takes even more time. In total, it's an average of 9 months, more or less, for a company to understand that it has been breached and to contain the breach in the sense of making sure that all the firewalls are in place. It's not anymore threatening the company, and you know what exactly was accessed. Now, if I'm a buyer in an M&A transaction, there is a good likelihood that at the point of buying the company, that company is within those 9 months period in which they either don't know that they have been breached, or maybe they know, but they think it's immaterial, and in fact, it's much bigger than that. And that's exactly what happened in Marriott Starwood. That's exactly what happened in Verizon buying Yahoo. In Marriott Starwood, Nick mentioned, at the point of purchase, at the time of purchase, nobody knew about the breach. Neither the buyer nor the seller. And that's very typical because companies just don't know until later on. That's one big problem. In the case of Verizon Yahoo, there was a known breach, but it appeared to be immaterial. And there I'm getting to your point about material adverse effect. It appeared to be immaterial at the time of the signing. After signing the agreement in which Verizon bought Yahoo in July 2016, the breach suddenly was identified as a much bigger problem. In September 2016, they thought it was, I think, 1 billion users. By December, it was maybe 2 billion. And the closing of the deal has not happened yet. So this is a scenario where you buy a target company in an M&A transaction, you sign the contract to buy it, you have purchase price agreed, everything agreed, but you haven't closed yet. It's not your company yet. And that opens up a situation where the buyer is trying to either get away from the deal or at least get reduction of the purchase price or other remedies from the seller. But the question is, what does the contract say? So if I agree to buy a company unless the company suffers a material adverse effect, and between signing and closing there is a breach, the argument then is over, is this a material adverse effect? And what does that mean? A company that has billions of users, but only 400 million users' data has been affected, is that a material adverse effect? A company whose systems have been locked down for 2 weeks, lost millions of dollars, does that constitute a material adverse effect? And these things are not defined in contracts. And a lot of the effort in M&A transactions is nowadays to, first of all, diligence the target, try to find what you can, and again, it's very, very difficult, but also create contractual protections that would help you in the event that you will find a problem. And in the case of Yahoo, Verizon got a reduction in the purchase price of $350 million out of $4.8 billion. But also Yahoo took on a lot of the potential litigation liabilities, consumer actions, I think they shared 50-50, and Yahoo took on all of the SEC and derivative actions. The board has to, number one, understand that this risk exists. So board of directors need to understand that when their company buys another company, there is a good chance that there has been a breach and nobody knows about it. What do? You ask questions. What kind of diligence was conducted? Any incidents were discovered that could become material? What kind of protections do we have in the contract? Even at a high level, these are questions that boards should ask because boards approve transactions. In the normal case, the board would approve the transaction, and that's a good opportunity to ask the right questions. Also, if the breach is discovered after the signing of the transaction, the board should be involved in the decision as to what to do. Do you nevertheless go forward despite the risk, despite the fact that it's not yet clear what would be the ultimate implication? Do you try to negotiate some concessions from the other side? These are big questions for a company because, again, back at the beginning, the potential threat is so big. And when you buy another company, remember, it's a point that I mentioned, it's not over on the closing day. Because after closing, the systems, the data of that company are often integrated with yours as a buyer. And if you bring in an existing breach that then can move laterally to your systems, if you bring in a serious vulnerability that then exposes your own system, your damages are not confined to what happened with this company. So if you bring a company that has 100 million users, your damage is not confined to the 100 million users. Potentially, it will affect your own. So if you have 1 billion users, they can be also exposed. So these are really fascinating issues, very difficult to deal with because of the difficulty to actually identify the breach, but these are issues that any board of a company that does M&A has to be aware of.
May I just add that M&A transactions are a huge issue for that very reason, as are vendor relations. You know, those also present the same opportunities for companies to really do some due diligence because they are increasingly being held responsible for their vendor security practices. This past year, the FTC started enforcement proceedings against a company for failing to oversee the security practices of a vendor with whom it shared consumer personal information. And so not applying that sort of due diligence and having contractual protections in place for you to be able to monitor the practices of your important vendors can create additional litigation and enforcement risk for companies.
Got it. Okay, well, let's move more into specifically the board and the board's role. Nick, you're probably, the primary person, and the CISO is generally the primary person who is there to educate the board and report to the board what's going on in the company. How does someone in your position prepare when you're going into a board meeting, knowing everything you know and knowing what, generally the board knows and really doesn't know?
Yeah, it's all CISOs sort of have a lot of discussions about this, of course. I think the critical piece is to have a group of leadership that helps you in the preparation of those. I live in the geek world, so we tend to be people that are highly technical. The board wants to understand the risk, but it wants it articulated in terms of business and financial implications and exposure implications. So what I found most useful is, I have to be brutally honest with the board. So certainly I prepare the material, but I work closely with the head of enterprise risk management, with legal counsel, with the CIO, head of IT, to try and make sure that these slides are communicating at the right level and has the right information. And so for me, although it's extremely painful, oftentimes going through 10 to 15 revisions of a slide deck, what happens is when I go into that room, I have a slide deck in which any of 4 or 5 people can actually speak to the points. And by doing it as a collaborative effort, because each of us sees the elephant from a different part, when we're in the room as corporate leadership, we're all projecting that we understand what an elephant is. No one of us can speak exclusively to it. In fact, the whole group has a lot of discussion about what is the elephant. And I think that's the most useful piece of advice to a CISO who's first starting to go into the boardroom. It's talk to the people that work with the board in these different dimensions, the dimension of IT, the dimension of law, the dimension of overall risk, and then make sure that you're talking in exactly that language and addressing the concerns of the board as heard through those other folks.
That's really good advice in terms of don't try to go it alone. Let me just give the verification code for the people who are waiting for the CLE. The verification code is 11611, and so you need to jot that down on the form that you're going to send back to Cleary to get the credit. Again, 11611. We actually have a question from the audience that I think ties into what you were talking about, Nick, in terms of enterprise risk management, just risk management in general. The question is, from your professional perspective, how involved should the board of directors be in understanding, assessing, and evaluating the cybersecurity insurance that a company puts in place?
Yeah, I think, of course, there are different ways to manage risk, but ultimately, of course, you accept the risk, you transfer the risk, or you mitigate the risk in one way or another. And I think ultimately, mitigating that risk can sometimes be implementing controls and other times invoking insurance to essentially round that risk. I think the board wants to be very confident that insurance is in place as appropriate, that it's carefully thought through. It's a difficult problem because I think the corporate leaders themselves are struggling to make sure that they understand what are the pluses and minuses of insurance. It's a new enough field. There haven't been that exhaustive of payouts that I think that ultimately they want to make sure that that's being handled properly. I'm sorry, Douglas, I just lost video as something cut out my monitors. Just want to make sure you're still hearing
you. So let's see.
Thank you.
I mean, Daniel, any comments on or any thoughts around insurance and board understanding, comprehension of cybersecurity risk insurance?
Yeah, people tend to focus on the amount that is recoverable. Boards might think that just because the insurance quotes $9 million for an incident, that's wonderful. But of course, as most of us who have insurance for anything from car to house to anything else know, it's really about the actual terms of recovery. And what's interesting, as Nick said, is that there haven't been enough payouts to know how insurance companies will try to avoid paying, which is really the issue. For example, and it will be interesting to follow this example, there is now a case pending in which an insurance company denies payment for a cyber security breach on the basis that the cyber attack was originated by Russia, as some news reports said at the time. And because it was an attack by a state, a nation, and because it's Russia, the insurance company claims that it is excluded from coverage as an act of war. And so hostility, or one of these things that nobody would really think of as taking away coverage for cyber breach just because it might be associated with Russia, or it could be Korea, China, Ukraine, or anything else. And I think it's really interesting to see that we are in such early stages of understanding what kind of exceptions will actually hold, what kind of carve-outs from insurance will actually hold in courts, that we should be very careful about those carve-outs and exceptions. And that's what I said in the beginning, boards should be focusing not just on the money, but also on those carve-outs.
Wow, that's fascinating in terms of state actor being considered act of war. But like you said, there's not enough of a sample set to really determine what's going on here. Let's see. Alexis, in terms of what you've seen from the litigation, what is any kind of views on what you've seen in terms of good board practices versus lax board practices in this area?
Yeah, I think there's some interesting information coming out of different proceedings as well as allegations and complaints that, if you look at it as a whole, can give a good picture of what at least regulators and perhaps plaintiffs' lawyers are considered to be good board practices versus bad. One example is the Yahoo shareholder derivative lawsuit. The complaint in that case, and of course these are just allegations, they try to portray a board that was actively hiding the breach, as opposed to just a board that was not necessarily that was asleep at the wheel, to say. So they point to allegations that the board didn't commit the proper resources, even knowing about persistent attacks by some state sponsors to attack their network. That complaint also talks about not requiring disclosure even after learning about the breach. So very basic things. I think also the Equifax settlement with the state attorney generals is interesting because in that case, they required a number of remedial steps that I think that are very detailed and actually give a good roadmap to at least what the state attorney generals think is a good program. So they focused on receiving regular reports and briefings about the company's cybersecurity measures, creating a new or enhancing their internal audit controls over cybersecurity controls, implementing and periodically reevaluating those controls as well, and being closely involved in any response to the breach. One thing that was notable about that breach is there seems to have been a lack of prior communication between management and the board about when the board should be notified of a data breach. In that case, the CEO waited for over 3 weeks after discovery of the breach, at a time when it was there were indications that it was a fairly large and significant breach. And so by waiting that period of time, there were certain failures in remediation, as well as statements that were issued that the board having board involvement, may have been able to avoid. So judging from those cases, it's key to have the board involved early if there's going to be you find out there's a significant breach, and also just taking the basic steps of oversight over the company's cybersecurity program to make sure that there are the appropriate controls and that management's paying the appropriate attention.
But I guess, what about the kind of argument in defense of the board, after the dust settles, where it's a situation where, look, the company has so many incidents, and you never know which one is going to turn out to be kind of the big kahuna. And so in terms of escalation procedures, for getting information about breaches up to the board early, you could be flooding them with information that ends up being, stuff that really doesn't pan out, doesn't turn out to be anything. So how do they deal with that?
Absolutely. As I'm sure Nick very well knows, major companies have hundreds, if not thousands, of potential data incidents on a daily basis. And so it can't be that every single one gets promoted up to senior management or the board. But companies can and should think when they're developing their cybersecurity plans as well as their incident response plans, what are the thresholds at which we want the board to be involved, at which the board would want to be notified. And by thinking about that in advance and making sure that they're clear, you can ensure that the board will be notified in the appropriate circumstances where you have the big kahuna of breaches.
Got it. And I guess before we leave, Nick, there's been some talk in the marketplace about, look, boards, they don't know enough about cybersecurity. There's debates about should there be a cybersecurity expert on the board, cybersecurity committee, etc. But in reality, you're not going to have all these board members understanding things at the same level as someone in your field. And so, some have suggested, well, maybe the board should have, on standby or get regular educational reports from an independent consultant, similar to the independent consultants they have for other things like compensation. Do you have any thoughts on that?
Yeah, I actually like the idea of establishing a separate training program, and it really is a training program for the board. And the advantage of the outside consultants is, as Daniel mentioned with regard to insurance, and for that matter in privacy law, so much depends on individual cases, case law, individual payouts of insurance companies. You really need to stay current with what are the current trends, because one thing about cyber is it's like engineering in a world where the physical constants change every day. It's always moving. And so what the board was doing a year ago is no longer adequate oversight, in all likelihood, to what the board needs to do today. So I like the idea of an independent consultant who keeps the board, number one, establishes a baseline of knowledge at the board about cyber, and then gives repeated periodic updates of how has the board role changed since we last met. And so I do like that. I like doing it independent from the CISO, because I think the board needs to build the confidence. And much of what I have to do, as you said, I get thousands of events per week, tens of thousands of events per week. They're filtered down. We may investigate 3 to 5 of them in depth. And every 3 months, I end up having to have a discussion about, do we let law enforcement take over this investigation? So these things do happen on a regular basis. I want to make sure the board can be asking the right questions to make sure I'm doing that at the right level and have established the right thresholds for informing them. And so the third party gives, I think, a much stronger feeling of confidence in the board, and they then come to me with more intelligent questions and also know when to keep me from going down a rabbit hole of technical detail. So I much prefer a well-educated board who has a strong opinion.
That's great. That's great. So I think that's important for people to hear from a CISO that this is a very useful and beneficial exercise for everybody. So at this point we are out of time, and so let me just kind of go through, review the CLE again. CLE credit, fill out the form, put down the number 11611, send it to Cleary along with the evaluation form. For CPE, just make sure you've entered your full name and email address and the specified CPE in the space provided at the bottom of your screen. We do have some interesting webcasts coming up. This Thursday, we have a Global Benefits and Compensation Roundtable webinar, again with our partners at Cleary Gottlieb, starting at noon Eastern. For our members, we're going to have a recording of a governance watch that we recorded with Cleary as well on long-termism, staggered boards, and hedge fund activism. So keep an eye out for that sometime in February. And then on March 5th, we'll be having our next regular Governance Watch webcast. And so really thank our panelists for joining us today, Daniel, Alexis, and Nick.